as a disabled person, he felt more vulnerable than another person. That would go towards him being able to establish a very real fear on his part, which negatives his intention to confirm his belief that he was the subject of a vicious attack.
Welcome back to the Legal Roundtable here on the Oscar Pistorius trial, a Carte Blanche channel. Now, before the break, we saw highlights from today's court proceedings. Now I'm joined in the studio by our legal experts. I have an defence attorney, James Aviard, the first of our advocates, Helen Ngumani, one of South Africa's top advocates, senior counsel, and Professor David Unterhalter, and a man well known to our panel, a former Zimbabwe High Court Judge, Chris Greenland. And I suppose, David, I could also put an acting judge's cap on your head as well for the purposes of this conversation. Welcome to all of you, four of you. There are a lot of legal minds here. Let me start with the cross-examination that we saw of Barry Roux. So much discussion about the way in which he does things, and also I think a lot of misconceptions about what the nature of cross-examination is. James, if I could ask you first, when it comes to expert witnesses, what is it that Barry Roux needs to achieve in order to bolster his case? This is obviously a state witness we're talking about.
Well, the thing is also, Barry Roux also said it himself, he's not as much a state witness as he's also going, well, particularly with Vermeulen, he's also could be a witness for Roux's case as well.
Yes.
So he needs to get aspects of evidence out of him that would bolster his own case. And strangely enough, simultaneously try to discredit aspects that are contrary to his case, ultimately. Yes. So obviously he has to scratch away at those little aspects which might not be that helpful to him, and at the same time be in a position at a later stage to argue the findings of Vermeulen helped his own case. So you can't absolutely smash him to absolute death, but you also need those aspects to come to the fore that are helpful to you.
Well, the words that resonated for me, Helen, was where he kept saying, I'm testing the value of a proposition through a witness. He kept saying to him, Colonel, I don't want you to accept, I want you to assume, and then put scenarios to him. What is he doing when he's engaging in that tactic?
Okay, David, thank you. That is a strategy from a cross-examiner. So he's trying to test him to find out if he will be accurate. That's why I say I'm assuming. So what he's doing is trying to find out from people whether he can remember certain facts that will be led in respect of what had transpired at the house at the time. So if he says I'm assuming, it's a tactic that he's basically using to elicit evidence that would be suitable for his case and advance his case and prejudice the case of the state.
David, you got some more to add on that? The tactic here of Barry Roux, what he needs to do with with an expert witness.
Well, there are a couple of things about this. The first is that often advocates are at some disadvantage in relation to an expert because they have the expertise and the lawyer has to learn the expertise to try and cross-examine the expert. What is often happening with cross-examining experts is that often expert evidence proceeds on certain basic assumptions. If you can test the assumption and suggest that maybe on a different assumption all the conclusions might well be different, that's often a tactic. So there are two fundamental things about cross-examining experts. One, test the assumptions on which the expert is basing himself or herself. And secondly, are all the facts that the expert has taken into account in reaching the view that the expert has? And those are two fundamental ways in which you can try and test an expert, and Mr. Roux is doing both.
Yeah, Chris, when it comes to being the judge on this matter, you've got an expert who gives you a version. We know that Barry Roux is going to put forward his experts who will give a different version based on the same facts, the same scientific evidence, I should say. As the judge sitting there, how do you weigh up which to accept and which to reject?
I think we get back to the fundamental, that before a judge, before Lady Justice, all men are equal. So you are an expert only when you prove it to the judge. So if I might use the example of this bullet, the black talent, if the one expert comes forward and tells the judge that the reason why that black talent bullet is so dangerous is because it's issued to the police. And it's issued to the police because it's got better hitting power and it stops people. And those are my reasons. And then the second witness says to the judge, "Judge, look at this bullet. You'll see that it's got linear striations on it." And what happens is that when it comes into contact with flesh, it fans out like a flower, and it also spins. And as you can imagine, Judge, what that will do to human flesh, you will see that the reasons of the second witness will convince the judge that this witness can be relied on. So as regards expert, the basic rule is you're not an expert until you prove it, and you prove it by the quality of your reasons. That is how a judge approaches an expert.
We're also looking at the way in which Barry Roux is looking at evidence that's overlooked, incompetence. How important is that a strategy against this expert witness? I'm not sure if he's impinging on the character and the abilities of this particular witness, Vermeulen, or on the police's case as a whole, David.
Well, I think it's often very risky to seek to impugn the expertise of a well-known expert. Sometimes this is done, but the more usual tactic is to show the respects in which an expert has not covered all the ground. And obviously part of what Barry Roux is doing is suggesting that there are at least some aspects of his evidence where he hasn't sufficiently looked at all the evidence and what the significance of that would be for his general conclusions. And so Mr. Roux is effectively going in to say, well, what haven't you looked at, and how might your opinion be different if you had looked at the things that I'm drawing to your attention?
I'm also interested in the way in which Barry Roux is conducting his cross-examination. We know this witness was specifically asked to investigate the strikes on the door by the bat, and there was a metal plate. But he's asking him a lot of collateral stuff as well about so many other issues and getting him to make assumptions. Why is he doing that? When this witness has said, I was there to investigate the marks on the door, wouldn't he just deal with those issues? He's dealing with a lot of other issues. You want to go over that one, Chris?
One aspect is that you will remember that in the plea explanation, unusually, the defense actually imputed bad faith to the state.
Yes.
So it's part of cross-examination for Advocate Roux SC to get as much support as he can as regards that aspect. So yes, he also pressurized Mr. Vermeulen on that basis, saying you were only interested in strikes, cricket bat strikes,
yes,
and you weren't interested in anything that supported my client. So yes, we can understand why he's doing that.
David?
There's another slightly unusual feature of this trial, which is that because Mr. Pistorius has given such a full account of what happened on the day, you have a slightly odd dynamic in this trial where what the state is doing is in advance showing the respects in which that version cannot be relied upon. And so one of the key things for Mr. Roux to do is to actually hold down the version of his client, which has been given in a lot of detail with each of the witnesses. And this expert, of course, has had things to say which would cast some doubt on the credibility of Mr. Pistorius's version. So he's got to go in hard, and he's got to try and sustain his client's version in the face of what this expert is saying. And that's a very key consideration for Barry Roux.
I think it's also important when he was, and he said it a couple of times to the witness, that you're not here to incriminate my client. Just explain that to me. This is a state witness he's talking about here, and the perception would be that the state witnesses are there to bolster the state's case. But he's saying you're actually here to assist me as well as the state. What does he mean by that, Helen?
Yeah. The use of an expert, it's not confined to say this is a state witness. The state witness is there to help the court to come to the right findings. So no one owns to say that the witness belongs to the state. His job is to assist the judge to reconstruct what had happened. So if words like you are trying to incriminate my client, I'm saying in cross-examination anything is allowed, David. It's either whether you want to reply to it and say no, or you offer or prefer an opinion to say why you don't agree with that statement. So the witness, the expert witness, is entitled to deal with those questions and reply If he does not agree with Mr. Rule's assertion, he must say so.
Yes.
Yes. So what I will say is that in cross-examination, anything it's allowed. The state never objected to that. They didn't say that was an unfair question to suggest to the witness. Yeah.
We'd have somebody on their feet saying it was unfair.
Yes.
Gerrie Nel on occasion has been doing that.
Yeah.
The style of Barry Roos come up many times on social media where people feel he's being too much of a bully or Gerrie Nel's too much of a puppy. But you made an interesting comment, James, before we came on. You said that when you've done cross-examination, you've never got away with asking a question more than twice. He's doing it for the 8th time.
Yeah, look, obviously I would think he's probably been granted a little bit more leeway because of the magnitude of the case. But I would say in general, when you're doing cross-examination, you try not to ask the same question over and over and over again, because the magistrate or the judge will tell you outright, move on. Move on to your next point. But perhaps in this attempt is trying to elicit a different answer on the 8th or the 9th time.
Well, he's not giving the answer that he wants. Is he getting too much latitude, Chris? I'm making you make a judgment on Judge Masipa there. I should be careful.
Far be it from me to come out with a judgment.
If you were a judge, would you allow 8 questions from a cross-examiner?
What I would decide in my mind is whether we've crossed the line, and the line is whether the questions are now not argumentative, frivolous, and vexatious, and they can be. If a witness is put in a situation where whatever answer or statement he or she made, she's in a no-win situation, and Michelle Berger might have been in that situation because she was pressurized on the basis of the consistency or similarities of her statement with those of her husband. Now, David, I can't understand the logic in saying that you're not going to see that level of similarity as between husband and wife, will be married for so many years, speak the same language, and witness the same incident.
Yes.
Because what would Advocate Roos' stance have been if there were significant dissimilarities? So in that instance, I would say, and I'm not wanting to be critical of the judge, I personally, and I'm not saying I'm right, I would have stopped him. I would have said, you're putting the witness in a no-win situation because for the reasons I've given, and the court is not supposed to be a torture chamber for human beings.
We'll continue this conversation after the break. We'll have a look at the continued testimony, the evidence in chief by the former police commander of the Boschkop police station.